All right, so is it an attack on the media, or is it, does Parliament have, the National Assembly rather, does it have good intentions? Today, we're going to try to put that into perspective, and we're talking to William Okechu, who's a commissioner in the Media Council, and he's also joined by Henry Minor, who's the regional director of Article 19. They're talking to Mutegi Njau on the same, and we know that you have some views and comments and even questions on the same, so we invite you to talk to us on 22422. That number again is our SMS number, 22422. Send in your questions, views, and comments, and also on Twitter. Let's talk on hashtag Power Breakfast. Good
morning, Mr. Maina. Good morning, Mr. Okech.
Good morning.
Maybe, Mr. Maina, we should start with the basic. Since you have got the bill that was passed here, maybe you should go through it and tell us the offending part of it, so that our viewers may know what are we talking about. Are we being unreasonable as media people?
No, I think we need to start by indicating that the passage of Powers and Privileges Bill was expected by our Constitution by virtue of Article 117 of the Constitution. It guarantees Parliament to have powers and privileges, but within the confines of what the Constitution has stipulated, to be able to allow Parliament to deliberate on matters that are important without unduly being gagged by any other agency. But we have to understand that then Parliament has extended that power beyond what is acceptable. So what they have done, they've gone ahead and limited 3 other rights that are equally provided for in the Constitution. The first that they have unduly limited is media freedom, which they are clearly creating now a crime called defamation of Parliament. And this, we must point out that it is in addition to other media laws that regulate the sector. So while MPs still have liberty to use Defamation Act in the event that they thought they were defamed and seek civil remedies, they are again playing in their own court by prescribing what would be thought offensive, determining what punishment you ought to get. So in this situation, the challenge is that they are the complainant, the judge, and the executioner in their own court. So that's already beginning to challenge a right on fair administrative action. So I've talked about they violated media freedom, they violated the right to fair administrative action, which says any complaint or any decision being made by a public or state officer must take due regard of certain principles of administration of justice. The third right that they are unduly limiting is the right to access and picket Parliament. So we need to know that the initial draft had talked about you being able to picket within and outside Parliament. They have reviewed that to say the Speaker will designate a place where you will picket. The Speaker may choose to designate Karioko. Yeah, you want to picket Parliament in town, but if the Speaker chooses to designate Karioko to be the point where you will be picketing Parliament, then that would be lawful. In that, they are already beginning to close the space within Parliament. So Parliament is no longer going to be accessible, neither can you as a citizen be able to picket and demonstrate against your MP or against a set of MPs, given whatever you want to move. And lastly is the question of accountability, because what Parliament has done, it has rejected a proposal from its own in creating a parliamentary ombudsperson, an oversight mechanism. Why was this proposal coming in? We've had numerous incidents in this Parliament and in the past Parliaments of questions of impropriety against MPs. We've had questions of misuse of allowances. Yesterday, I think in fact in Mombasa court, We had a case of an MP, a former MP, who hasn't paid their workers within the Parliamentary Service Commission rules. Where do you take these complaints if you are Kenya? So for me, the nut end of this process is that Parliament has made itself an enclave of impunity.
So what are the sections that...
The sections that are offending,
yes,
largely are, first is Section 34, which creates the crime of defamation against Parliament. Section 35, which creates the penalty for the person who may then be deemed to have defamed Parliament. So Section 35 begins to prescribe that if found to have defamed Parliament, you will then be liable to, if once convicted, you're liable to a fine not exceeding 500,000 and or being jailed for a 2-year period. So that's one set that is offending. They removed clause 27, which had criminalized broadcasting of parliamentary proceedings, which would immediately have run counter to Article 118 of the Constitution. So they've removed that. They were also clever to remove Section 36 that was asking the clerk and the speaker to be able to invite the Director of Public Prosecutions into investigating any allegations of impropriety. So you begin to see the connection that they want to ban the media from covering them, but they also want to ban the prosecutor from coming in to investigate any issue. So it's not just a fight about the media. It is a fight against Parliament being held accountable.
Mr. Okech,
yes.
What is your take on this?
Well, what happened in Parliament yesterday is very sad because you really need to look at the history of criminal libel law. Essentially, the clause, especially clause 34 that Maina has talked about, it is everything to do with criminal libel, which is sedition, and it is a very old provision in our laws. When you look at the history of this law, you realize it is a law that was used by governments, one, to make sure that the public did not criticize government, and two, to make sure that there was gagging of the public in terms of what they should say and what they should do. In 1997, through the IPPG, Kenya at that time made amendments to the law which did away with sedition at that time. And also when you look at the history of progressive nations, the UK did away with their criminal libel laws in 2009. New Zealand did away with their laws in 2007. South Africa similarly did away with these laws. The chilling effect of this provision, when you talk about defamation of Parliament, all that you need to do is to prove that a certain journalist published a material. When you take this journalist to court and charge this journalist, then even if the MPs were to argue that this is a limitation of Article 35, there is, when you look at Article 24, there is a standard criteria that outlines what a justified and reasonable limitation ought to be. And one of those reasons is that, is there an alternative way, a less restrictive way of dealing with that limitation? For this particular case, for example, if it was the issue of parliamentary mileage claims, where it is on record that there have been issues. If, for example, I was a journalist and I do a story on that issue, then all that the Speaker will need to do is to invite the DPP to investigate me. I will be arrested. I will be taken to a police station. Possibly I will be denied bail on bond. I will be charged. In the event that such a journalist will lack a good defense, because in such crimes you find that if, for example, it's an issue of corruption, it is very hard for me to prove that corruption, though I may have good indications to that story. So I will be convicted. You may want to ask yourself, what will be the effects of this conviction? One, it will mean that as a journalist, you will have a criminal record, and you will not even be able to get a certificate of good conduct for that matter. Two, it will be stifling genuine and critical accountability concerns. Because in 2010, Kenya passed the new constitution. And when you read through this constitution, Mutege, you'll realize that the golden web that runs through this constitution is the issue of accountability. From Article 10 that demands of accountability and transparency, and even the national executive, the president is entitled every year to give a state of the nation address and to outline how issues of accountability are being handled. In the judiciary, even the Chief Justice gives a national report on how the workings are. You will realize that it is only Parliament which does not have an equivalent provision where the Speaker gives an accountability. Why? The reason is because the Article 118 provides for Parliament for the proceedings of Parliament to be open to the public and to the media. The consequence of this is that journalists have to be allowed to report without any threats, without any intimidation.
Mr. Maina, what do you, in following this, what do you think could be done?
There are two things that could be done to remedy the situation. I don't want to blame the whole Parliament. I just think that a few of them may have had personal issues, which then yesterday carried the day, as opposed to perhaps collectively as Parliament saying we are a representative body. We do not come into this house on our own accord. We've been asked by our electorate to represent them. And because that's the nature, I think there are two things that are still going to be done. One, that the bill needs to proceed to the Senate, where the Senate would either affirm every clause as is, or in their own deliberations, they will introduce other clauses that may differ. So one way, if you are a total pessimist, you might think that they will introduce more offending clauses. So they might even bring back the one on whoever broadcasts their sessions. We know that in the counties, Nyeri, Kwale, Migori and Homa Bay, yesterday journalists have been banned from covering the county assembly sessions. So on one side there's still tension, and Kenyans need to be vigilant that our representatives, our messengers, have turned out against the principle. But two, on the positive side is that the Senate can and should be able to listen to the principal, who is the citizen, and understand that while we recognize that the Constitution provides for powers and privileges, in fact it uses the language Parliament may develop regulations enabling powers and privileges of Parliament. But when it goes to the Bill of Rights on media freedom, it says the media shall not be subjected to any interference. So that is a mandatory provision. This other one is a provision that in the event you think it's necessary. So on the positive side, we need to go to the Senate. We need to think through with the Powers and Privileges Committee of the Senate. We need to think through with the ICT Committee of Senate and be able to show that some of these clauses are offending and may not sit pretty with the Constitution. So that's one way. In the event that the Senate agrees or concurs with the National Assembly, then we have to continue our advocacy to the President, asking him to be magnanimous enough and defend the Constitution that he swore to defend all through. In the event that fails, we will have to run to the courts to challenge the constitutionality of some of those provisions. And so it's going to be a protracted process. Remember, this is also the period where there are more questions about mileage claims. There are more questions about how Parliament has spent money on foreign trips. So it is a hard time for the country. We need not drop the ball. But we also need not forget that this bill also sought to introduce some positive clauses. I need to be able to point out that the bill provides now for a right of reply for any citizen who might be adversely mentioned in parliamentary proceedings. This is something that has never been in existence. So you notice MPs using parliamentary privilege and knowing it's an absolute privilege tend to throw names around parliament, and they know that they are totally covered. You now have an opportunity to complain, and the Powers and Privileges Committee would be able to hear you and suggest the best way in which you can get some right of reply. So that is a positive thing. Another positive thing that they managed to delete the clause on allowing the speaker to dictate when proceedings would be broadcast or not. So those are positives, but they are too little given the poisoned chalice that is with these other clauses. So that's the process we need to continue engaging. I think all Kenyans have to get back and understand we are the principals. You need to talk to your MP. You need to ask them questions. You need to say, how am I going to be able to continue seeing you as my mjumbe, as they say in Kiswahili, as opposed to mheshimiwa. Mjumbe ni mtu aliyetumwa. So we need to remind them that they are our emissaries. They are not our bosses. We pay them, and if they do not understand that, of course, they will keep arguing that an election is a recall process. They are able to be held accountable. But between elections, MPs too have to be held accountable just like anybody else. So nobody is undermining them, and nobody is saying that MPs should be defamed or their reputation should be impugned without due regard. We're saying there are other sets of laws that exist that protect any other Kenyan and protect MPs in the event that they feel that their reputation has been put into disregard in the eyes of right-thinking Kenyans. And they have those provisions to use, and those would be civil provisions. The idea that our penal code still retains section 194 to 200, which talk about criminal defamation. We still retain provisions on publication of false news. We still retain provisions on insult laws, begins to make us not the democracy that we are yearning to be. And for me, that is the biggest challenge. At this time when Kenya was saying we are an example of what a democracy can be, democracies think different. In fact, William was referring to UK. UK has powers and privileges defamation amendment bill, which allows MPs to waive their privileges in the event that they think it will serve more public interest, so that they speak out and they can be prosecuted or they can be able to engage in public debate without the immunity around them, because they need certain things done. But here, instead of having that waiver that MPs can fall to, we are entrenching privilege. And yet, our constitution is very clear. Citizens of this country are sovereign. In the UK, remember previously, Parliament was sovereign, because as a monarchy, the only elected people were the MPs. That's why the concept of parliamentary sovereignty in UK is different. Parliament is not sovereign in Kenya. Citizens are. And that's what I need to be able to reiterate. So all is not lost. We would engage them. We will continue to engage in good faith that they did their part in passing a law. The law has fallen short of the constitutional requirements, and we need to continue engaging, speaking with each other, not at each other. We don't need to hurl abuses or insults at each other. That's what democracy would expect of us.
This bill does not only, it's not an affront on the media only.
Yes.
The wananchi are affected. Can you demonstrate how ordinary people are affected by this bill?
Certainly. You'll find that on the first front, taxpayers and the ordinary monanchi, they pay taxes, and some of these taxes go into the public fund, which essentially should be for the provision of services. In the event that there is misuse of some of these taxpayers' money, there will be no adequate accountability mechanisms. Take, for example, the issue of investigative journalism. Our brother John Allan Namu and Muhammad Ali will find it very difficult Because the moment you make an expose, you'll be exposing yourself to a criminal prosecution. When you look at the statistics, Mutegi, right now, the amendment which was done by Parliament yesterday puts Kenya on the same leagues with countries such as Egypt, Saudi Arabia, because when you look even the number of journalists who are in prison in Egypt, over 95% of them were prosecuted on criminal libel laws, because all that the state needed to prove is that you publish this. The Constitution requires that any limitation of the right of the media, it has to be reasonable. And before even thinking of a limitation, you ought to ask yourself, is there another less restrictive way? Maina has mentioned that we have the Media Council Act, which establishes the Complaints Commission, where all journalists are supposed to adhere to the Code of Conduct for the practice of journalism. Should they fall below standards, there are adequate remedies. Anyone, including the MPs, can lodge a complaint at the Media Council. The Commission can adjudicate on this matter and issue sanctions, and their punitive sanctions. A journalist can even be suspended from the role and denied practicing. Therefore, this is not a very good law, because even when you look at globally, even regionally, the African Union Rapporteur on freedom of expression, Madam Pansy Zakula, has made her stand known that criminal libel laws does not have a place in this country. The African Parliament in South Africa made a resolution, the Table Mountain Resolution, calling on African states to repeal their criminal libel laws. So it will make anybody wonder, why is it that on certain issues Kenya would want to align itself with AU policies, while on issues which are self-beneficial they deviate from that. So essentially this is a bad law. It takes away the right of accountability of the citizens to question their MPs and to question the way they use public funds. And even when you look at Article 73 on leadership and integrity, every state officer is required to be honest and diligent in the execution of their duties. When you look at this saga, the moment it started, you will be hard-pressed to say that the MPs have not been honest. Because all along, as you mentioned, the Honorable Adan Keynan had made commitments that those clauses will be deleted. The Speaker of the National Assembly, I think in a forum with the editors, had gone on record and made commitments that those clauses will be deleted. But then eventually when it came to the floor of the House, you find that the story changed. So it is a bad law. It's not good for Kenya. If we are to call ourselves a progressive and open democratic nation, it is bad. There are adequate remedies in civil. If I'm a journalist, I write something bad against you, take a lawyer, sue me for civil defamation, and court will award damages, which are commensurate.
Final, Ms. Maina, before you're running out of time, what do you think the Article 19 or the Media Council or media institutions can do, apart from the process of how they have to go to the High Court? What can they themselves do? I think not the process through Senate, through the President and then the High Court. What can they do?
One, the media industry has to slightly wake up. I did an analysis of this bill in November 2014. I raised concerns that this was a bad law. I can tell you that it wasn't covered by many people. I trained all Kenya Parliamentary Reporters Association in January. I even called Honorable Adan Keynan into the meeting, pointing out that there is a problem. But this is a typical Kenyan media challenge. You wait until you are half drowned to begin gasping for the air and saying, what can we do? I hear you, Mutegi, you are a senior journalist, you are a senior editor, you need to go back and rally your troops. What is the basic you can do as for yourselves? I'm a former journalist. Fortunately, I left earlier. Perhaps it would have been worse for me. But I want to say, whatever decision you would make as editors and journalists, you can count on Article 19 to walk with you a long way. Not that we want to be disruptive of rule of law and order. We want to petition. We want to question processes within a rule of law process. So I'll leave that in your court as a senior, as Mzee, that you need to make that decision. You have people who are willing to rally with you. I know that we brought here Commissioner Pansy Tilakula just the other month. And this goes against a whole African system. in December last year, the African Court made the decision, Konate versus Burkina Faso, declaring criminal defamation provisions in Burkina Faso as violating the African Charter, Article 9 of the African Charter. How may we continue to claim to be Africans even when we defy our own institutions? So that is very clear. But I rally editors, I rally Kenya Union of Journalists, Kenya Association of Media Women, Kenya Correspondents Association, and all other entities, that this is the time to forget your differences, rally your troops together, think the way MPs think collectively, and make a decision. We will be able to back you up and do what is necessary.
What do you think the Media Council can do?
The Media Council will, in liaison with other stakeholders, first we are looking at a stakeholders meeting so that we thrash these issues, to lobby. If the bill is on its way to Parliament, to Senate, is to lobby Senate to remove that provision and those provisions which are unconstitutional. Should that fail, then the other avenue will be to lobby the President not to accent that bill. Should that one fail also, we'll have to now move to the courts to challenge the constitutionality of this law.
What would happen if the media houses, the media owners, the journalists decide to boycott Parliament? Would that be traversed? Is that a possibility?
It is a form of protest, and protests are legal. They are provided for in our constitution. So if that is a decision you've made, to the extent that you do not do that disruptively, it's still one of the options available.
Thank you very much, gentlemen. We have run out of time.